Edinburgh, specializing in intellectual property laws. Her research interests encompass intellectual property laws, data protection and privacy laws, and the interface between artificial intelligence and law. Prior to her full-time academic career, Ma'am served as a full-time research fellow with the IUCIPRS, CUSAT, and CIIPC at NLU Delhi. Amity University welcomes you, ma'am.
Thank you. Good afternoon, everyone. Honorable Vice Chancellor Professor Dr. Piyush Kant Pandey, Honorable Pro Vice Chancellor Professor Dr. Sumita Dave, Honorable Head of the Institution of the Law School, Dr. Abhinav Pradhan, the organizing team, panelists, participants, and members of the audience. It gives me great pleasure to be here today, virtually at the conclusion of the National Conference on Artificial Intelligence and Law. I take this opportunity to thank the organizers of this conference for their kind invitation. Not too long ago, the legal world was captivated by a cautionary tale from a New York courtroom. In the case of Mata versus Avianca, two experienced lawyers were sanctioned by a federal judge. Their mistake? They had submitted a legal brief filled with eloquently written but entirely fictional case precedents. These phantom cases, complete with fake citations and bogus legal reasoning, had been generated with confidence by ChatGPT. When confronted, the lawyers admitted they were unaware that this content could be false. This incident is more than just a piece of legal trivia. It is a foundational lesson for our time. The failure was not one of technology, it was a failure of professional responsibility. It highlights a dangerous temptation to accept the output of a machine with suspension of the critical judgment that is the hallmark of our profession. That case serves as the perfect overture to our conversation today, reminding us that as we integrate these powerful tools, the ultimate accountability remains and must always remain human. We stand at a remarkable juncture in human history, a point of inflection where the lines between the architect and the architecture are blurring. We began this conference with a question and we conclude with a reflection. We have proven we can build these systems, but have we committed to truly understanding what we have built? Across both yesterday and today, this conference has been a crucible for the ideas that will shape our legal future. The papers and presentations have spanned the entire spectrum of AI's engagement with law, creating a rich yet contradictory narrative. On one hand, there is a palpable sense of optimism. We heard about the future of community lawyering and how AI can be integrated with human centered legal services to increase access to justice. We explored how AI driven legal research can enhance the efficiency and accuracy of legal analysis, promising to democratize capabilities previously available only to the largest firms. We explored, we have journeyed, in fact, from the theoretical questioning the legal personality of AI and the secrets of black box to deeply practical discussions. The discussions on AI roles in judicial decision making, intellectual property, and its intersection with constitutional rights have been enlightening. Yet, this optimism was rightly tempered with profound caution. We were confronted with the difficult questions of algorithmic bias, whether use of AI in judiciary would be a transformation or, in fact, a threat. This conference has not provided easy answers, and that is, in fact, its strength. It has instead armed us with sharper questions and a more nuanced understanding of the path ahead. It has shown us that landscape of AI is rich with opportunities, but also fraught with challenges that we as a community must navigate. The integration of AI is no longer a futuristic concept or just an academic debate. It is a present-day reality and a core strategic imperative for law firms. The adoption is moving from the periphery to the very center of legal operations, fundamentally altering the how of legal work. Let's be more specific. In large-scale litigation and regulatory matters, technology-assisted review, which is an AI-driven process, is now becoming the industry standard for e-discovery. Instead of armies of junior lawyers mutually sifting through millions of documents, an algorithm can be suitably trained on a small, relevant data set. The system can then intelligently prioritize and categorize the rest, reducing review time and costs. In the corporate law world, AI powered contract analysis tools are hugely helpful. These platforms can ingest thousands of complex legal agreements and within hours extract critical clauses, identify risks, flag non standard language, and even benchmark terms against market standards. The work of a junior associate is evolving from the manual drudgery of due diligence to the sophisticated task of supervising these systems and analyzing their output. A significant revolution is also underway in the foundational task of legal research. The field is beginning to move beyond simple keyword searches with the emergence of platforms that employ natural language processing. The goal of these tools is to allow a lawyer to ask a complex legal question and receive a more intuitive result, not just a list of cases, but a ranked analysis of relevant precedents, perhaps even highlighting judicial language that has been influential. This trend points towards a powerful shift, likely to impact everything from law firm economics to the training of future lawyers. However, this technological appropriation thankfully is not happening in a vacuum. It is prompting a crucial response from our governing institutions, fundamentally shifting the public policy landscape. The judiciary, which is often seen as a traditionalist, is in fact leading a very fascinating and proactive conversation. An example is the recent policy on the use of artificial intelligence in judiciary by the High Court of Kerala. It is not a speculative paper, it is a functioning policy. The court has formally approved the use of AI tools for tasks like legal research and summarizing case file for judges. It is a bold step towards enhancing judicial efficiency. However, the policy comes with a critical and a bright red line. AI is to be an assistant, a clerk, a researcher. It is explicitly not to be used for judgment, adjudication, or judicial decision making. This action by the Kerala High Court also does not exist in isolation. It is part of the broader technology positive movement within the Indian judiciary focused on a core constitutional value, that is access to justice. Another example of this is the Supreme Court's Vidik Anuvad software project, the SUAS project. It is an AI powered tool that is at the heart of an ambitious initiative to translate Supreme Court judgments from English into India's numerous regional languages. As of this year, many judgments have already been translated and made available on the ESCR portal, breaking down language barriers that have long prevented ordinary citizens from understanding the law of the land. This is AI in service of the people, a tool to actually empower, but also to include. It also aligns with the broader national vision that we have articulated in Niti Aayog's National Strategy for Artificial Intelligence, which champions a philosophy of AI for all. However, AI must contend with the legal architecture of our new Digital Personal Data Protection Act, the DPDPA, because the voracious appetite of AI models for data will constantly be tested against the DPDPA's principles of consent, purpose limitation, and data minimization. So, if we look globally, India is actually carving its own path. We are not pursuing the comprehensive and, as some might say, the heavy handed risk based regulation of the European Union's AI Act, nor are we fully embracing the market driven sector specific approach that United States has taken. India, in fact, appears to be building a hybrid model, one that fosters innovation while also empowering the state to intervene when it is necessary. How we navigate this path will, I think, be one of the defining policy challenges of the next decade. But while we celebrate these institutional successes, we must also confront the profound societal challenges this same technology presents when placed in the wrong hands. The very accessibility of AI has unleashed new and potent threats to our social fabric. One of the most immediate threats is the proliferation of deepfakes, hyper realistic but entirely fabricated video or audio content created by AI. We are no longer talking about a distant threat. India has, in fact, become a hotbed for this malicious technology. We saw this during the recent election cycle where a deepfake video of actor Ranveer Singh appeared with his voice cloned to make it seem as if he was criticizing the prime minister. This was a clear act of political manipulation. We saw the personal and reputational harm it can cause when a morphed video of actress Rashmika Mandana went viral. It highlights the vulnerability of women to this form of digital harassment. We have also seen the likeness of icons like Sachin Tendulkar being used without consent to promote online gaming apps. These examples are not outliers, they are evidence of a growing crisis. The core danger of deepfakes is not just the harm to their victims, but the systemic damage that they do to our collective trust. In a world where we cannot believe what we see and hear, the very foundation of evidence and public discourse begins to crumble. Equally problematic is the impact of algorithms that govern our digital lives. Social media and content platforms use AI to decide what we see, optimizing for engagement. The unintended consequence of this is the creation of echo chambers and filter bubbles. These systems learn our biases and feed us a steady diet of content that reinforces what we already believe while insulating us from differing viewpoints. In a country like India, this presents a problematic challenge. We have witnessed one of the fastest and most expansive penetrations of smartphones and mobile internet in human history. Hundreds of millions have come online for the first time. However, this explosion in access has not been matched by a corresponding growth in digital literacy. What this results in is a vast population that is highly susceptible to the polarizing effects of these echo chambers and vulnerable to targeted misinformation campaigns, which in turn can exacerbate the already existing social divisions and also undermine our communal harmony. Let us also consider the business model of this revolution. Many of these most powerful generative AI tools are now being offered to the public for, in fact, free or at a very negligible cost. We must ask ourselves the fundamental question our profession trains us to ask: why? What is the consideration here? Because when the service is free or for a negligible cost, the user is often the product. Every legal query we type into a public facing AI, every document we upload for summarization becomes data. This data is the lifeblood that trains and refines these commercial models. So we are in effect the unpaid tutors for the next generation of these models, refining their capabilities and deepening their reach into our lives and our work. For legal professional, this raises immediate and severe ethical concerns. How does using such a tool align with our duty of client confidentiality? Where is that sensitive data being stored? Are we inadvertently co-creating a system with unknown biases and unknown ownership? These are not abstract risks. They are potential breaches of professional conduct. This leads us to one of the next societal challenges, which is the impact on education and critical thought. AI holds incredible promise as an educational tool, particularly in promoting accessibility. It can act as a reader for a visually impaired student or a personalized tutor for those with learning disabilities. However, there is a growing body of research and concern from educators worldwide about its potential to atrophy the very skills it is meant to support. Legal education at its core is not about memorizing laws. It is about building a specific kind of analytical mind through the rigorous, often frustrating process of case analysis, logical reasoning, and structured argumentation. When a machine can produce a flawless essay or a coherent legal memo in seconds, it allows the user to bypass the crucial intellectual struggle. So the risk is that we may be raising a generation that is adept at finding answers, but has lost the ability to formulate the questions, to think critically, and to build an argument from ground up. This brings us to our final and most important reflection. In the face of such powerful automation, we must be vigilant against the dazzle effect. If we are too easily impressed by everything that AI does, we risk losing our critical faculties and our objectivity. Therefore, we must resist the temptation to outsource our thinking. A useful concept here is that of the moral crumple zone. It is an engineering term used for the part of a car that is designed to collapse on impact to protect the passengers. In technology, humans are often positioned as the moral crumple zone. When an autonomous system fails, the human operator is the one who bears the blame. This is exactly what happened to the lawyers in the Meta Avianca case that I mentioned. They were in this position that they were to take the blame when the technology didn't do what it was supposed to do. That is precisely why we must champion the skills that are and will remain uniquely human. An AI can review a contract, but it cannot sit with a client, understand their fears, and provide counsel that is not just legally sound, but also deeply empathetic. And AI can analyze data to predict the outcome of a trial, but it cannot stand before a judge and weave a narrative of justice that is equally compelling but also persuasive. It cannot engage in the creative problem solving of a complex negotiation or exercise the nuanced ethical judgment that defines our profession. The future of law does not belong to the AI, nor does it belong to a lawyer who resists this technology. It belongs to the lawyer who can master the art of this human machine partnership, who can leverage the incredible power of these tools without ever abdicating their own critical judgment, professional ethics, and fundamental humanity. In conclusion, I would like to say that the future of AI and law is not a spectator sport. It is a challenge that demands our active participation, our critical inquiry, and our unwavering commitment to the principles of justice we are sworn to uphold. I will leave you all with this thought. The true test of our intelligence is not in our ability to create artificially intelligent machines, but it is in how we choose to be human in its present. I once again thank the organizers for this opportunity today. Thank you very much.
Thank you so much, ma'am, for your kind words. Now I would like to invite Dr. Sukriti Chakrabarti, ma'am, for providing us with a concise summary of the technical sessions held.
A very good afternoon, everyone. The session commenced with an address by Mr. Toshan Chandrakar, who emphasized that artificial intelligence is not merely about programming an algorithm, but is intrinsically linked to value sovereignty. He highlighted the importance of India's role in AI, urging the nation to inspire not just to be a consumer, but also a creator of AI technology, and stressed the need for regulation in technology. Dr. Abhinav Pradhan sir, head of Institute, Amity Law School, discussed how AI impacts trademark and copyright laws in the era of fourth industrial revolution. He addressed critical questions surrounding trademark and copyright registration in the era of AI. Pro Vice Chancellor Dr. Sumita Devi, ma'am, highlighted the diverse applications of AI and how it can deepen knowledge and promote exploration across fields. The event continued with Honorable Vice Chancellor Sir's address. Professor Piyush Kant Pandey introduced the Supreme Court portal, SUPAS, and explained how AI can improve judicial outcomes. The session was then addressed by our chief guest, Professor Atul Kumar Pandey, who shared in-depth insights on artificial intelligence. He recalled the introduction of Internet in India in 1995 and the enactment of Information Technology Act in 2000. He stressed the importance of AI regulation and referred to Hobbes' definition of personhood to explain AI. He also raised a critical question about liability in AI-generated intellectual property infringements, highlighting the urgent need for new legal frameworks. In the panel discussion, in the first panel, explored artificial intelligence as a transformative technology and addressed the risks of black box AI. Panelists discussed the intersection of constitutional rights and AI, emphasizing that AI lacks the social understanding needed to be a competent lawmaker. In the second panel discussion, highlighted bail developments through Jaswinder Singh versus State of Punjab and explored all AI tools, algorithms, and accountability. Judicial decision making was discussed with cases linking AI to natural justice, advantages, risks, and ethical concerns. In the third panel, participants shared that AI is increasingly ruling the world, influencing people, and can become a threat if its limits are crossed. In the fourth panel, it was discussed the urgency of recognizing AI in legal research, comparative perspectives, and suggestions for future use. It also covered categorization of AI, including trading bots and algorithms, highlighting current challenges with China as a competitor and their economic impacts. In the fifth panel, the participants highlighted the linkage of AI and data privacy with BSA and BNSS, questioning whether AI can be trusted without proper legislations. In the sixth panel, participants highlighted that AI is increasingly ruling the world, influencing people, and may become a threat if its limits are crossed. In the seventh panel discussion, the participants highlighted deep fake videos as a major cause of erosion of trust and facilitation of fraud. They emphasized the relevance of K.S. Puttaswamy judgment and Article 21. In the eighth panel discussion, it was discussed that AI boosts efficiency and transparency, but must follow ethical and legal limits to prevent bias and misuse. In the ninth panel, it was discussed that EU's GDPR ensures comprehensive rights-based protection, while the US follows a fragmented, innovation-led model with regulatory gaps. In India, existing laws like the IT Act 2000 and the new Data Protection Act remain limited as AI adoption grows. In the last panel discussion, it was discussed that AI supports judges as a decision assistant, aiding research and case management, but leaving rulings to humans. Our keynote speaker for today, Mr. Devrat Vaishnav, also spoke on transformative potential of AI and its challenges. He pointed out issues of bias, giving example of Amazon's recruitment tool discriminating against women, lack of informed consent, and unauthorized data use. He further discussed the legal dilemmas, stressing that since AI lacks consciousness and criminal liability, accountability rests with humans. He concluded by underlining litigation complexities such as absence of precedents, shared responsibility, and the black box nature of AI. Our final keynote summary speaker, Ms. Saraswati Vaidyanathan, emphasized that AI can analyze data but cannot engage in the ethical nuances of legal framework. AI must not erode the fundamental rights or diminish the human element of justice. Thank you so much.
Thank you, ma'am. Standing here at the conclusion of a conference feels less like an ending and more like a continuation, a moment to pause, reflect, and celebrate what we have experienced together. When we envisioned this conference, our goal was simple yet ambitious: to create a space where legal minds, technologists, policymakers, and students could come together and reflect on how artificial intelligence is reshaping the world of law and justice. AI is no longer a distant idea. It is already here, influencing research, compliance, advocacy, and even the delivery of justice. But with these opportunities come vital questions. How do we protect rights and privacy? How do we balance innovation with ethics? And how do we ensure technology serves society rather than replacing the values that define it? Over the past 2 days, we have engaged in rich discussions and exchange of ideas that opened new perspectives and sparked important questions. While views may have differed, what united us was the shared commitment to think critically about this fast evolving intersection of law and technology. If there's one message we take home, it's this: the dialogue between AI and law cannot end here. It must keep evolving just as technology itself evolves. This is not the finish line, but the beginning of many more conversations and collaborations. Without a further ado, I would like to invite Assistant Professor Shruti Srivastav ma'am to kindly deliver the vote of thanks.
Thank you, Suhani. Good afternoon. Good afternoon to one and all present here. As we conclude this conference, I, Shruti Srivastav, faculty co-coordinator of the conference, would like to express my sincere gratitude on behalf of Amity Law School, Amity University, Chhattisgarh. To all of you who have contributed to the rich dialogue and exchange of ideas over the last 2 days. To start with, I would like to extend my heartfelt gratitude to our Honorable Founder President, RBEF, Dr. Ashok K. Chauhan, Sir, President RBIEF, and Chairman, Amity University, Chhattisgarh, Dr. Asim Chauhan, Sir, Honorable Chancellor, Amity University, Chhattisgarh, Dr. W. Silvamurthy, Sir. I would also like to express my deepest sense of gratitude to Professor Piyush Pandey, Sir, Honorable Vice Chancellor, Amity University, Chhattisgarh, for his constant motivation and support. My sincere gratitude to Honorable Pro Vice Chancellor, Professor Sumita Dave, ma'am, for her constant support and guidance. I thank our Registrar, Dr. Suresh Dhyani, Sir, and the office and his office, all the deans, directors, HOIs, and my faculty colleagues for their enormous cooperation in the organization of this conference. I would also like to thank the university administration team, IT support team, and ESCO team for their support throughout the conference. My words today would not be enough to express heartfelt gratitude to our guest of honor, Professor Dr. Atul Kumar Pandey, sir, who took out time from his hectic schedule and graced the event. I would also like to extend my gratitude to our esteemed keynote speakers, Ms. Saraswati Vaidyanathan ma'am and Mr. Devrat Vaishnav sir, who enriched the conference with their profound knowledge. I am equally thankful to the distinguished panelists whose insightful deliberations on the interplay between artificial intelligence and law have deepened our understanding. Furthermore, I would also like to acknowledge the participation of all the participants and attendees. Your engagement, questions, and discussions have enriched the conference and made it a truly collaborative and thoughtful experience. We have been fortunate enough to be backed by a team of very motivated and dedicated student volunteers who have worked tirelessly to ensure the smooth conduction of the conference. Your dedication and hard work have made this event possible, and I deeply thank all of you. I cannot thank everyone enough involved in the conduction of the conference. Thank you once again and have a great day ahead. Thank you.
Thank you, ma'am. I would request everyone to rise for the national anthem.
जन गण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्छल जलधि तरंगा तब शुभ नामे जागे तब शुभ आशीष मांगे गाहे तब जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय जय जय